On behalf of all the organizations represented here today, so namely the Global Policy Institute, the Center for Commercial Law Studies, the Digital Environment Research Institute at Queen Mary University of London, as well as the Society for Computers and Law, the International Bar Association, and the Alan Turing Institute, welcome to this second webinar in a series looking at artificial intelligence. So whether we realize it or not, artificial intelligence touches upon our daily lives. Often unnoticed, it makes our tasks easier. However, the other side of AI deployment can have devastating impacts on the lives and the freedoms of individuals. So our focus today is on AI and human rights, and it is planned to coincide with International Human Rights Day, which will take place later this week. I am Theodora Christou. I convene Transnational Law and Governance at the Center for Commercial Law Studies, and I am co-moderating today's webinar with Fernando Barrio, a senior lecturer at the School of Business Management at QM, as well as being the academic lead for sustainability and resilience at the Global Policy Institute and a trustee of the Society for Computers and Law. What we will do is we'll start off with some introductory comments from Professor Greg Slabaugh. He is the director of Queen Mary's newly formed Digital Environment Research Institute. The institute focuses on multidisciplinary research in digital and data science. Greg is also a professor of computer vision and AI, and also Queen Mary's Turing Institute lead at the Alan Turing Institute. Greg's career spans both academia and industry, having worked in technology companies in both the USA and the UK on consumer and also medical devices incorporating artificial intelligence. So who better to set the scene for our discussions? Greg, over to you.
Thank you. Thank you so much, Theodora. It's a great honor to be part of this event and set the stage for today's exciting panel session. Since I'm a computer scientist, I thought I'd start off with artificial intelligence, or AI. AI lacks a precise definition, but John McCarthy, one of the founders of AI, describes it as a field that leverages computers and machines to mimic the problem-solving and decision-making capabilities of the human mind. AI has had its ups and downs since the early days of the 1950s. Currently, though, AI is booming, fueled by the availability of big data, high-performance computing, and breakthroughs in learning algorithms. In particular, deep neural networks have shown stunning performance in different disciplines, such as translation between languages, image classification and synthesis, or predicting 3D shapes of proteins. AI is embedded in many of the tools and services we use daily: web search, processing of financial transactions, navigation to avoid traffic jams. Sometimes you take AI for granted as it is implemented behind the scenes, as Theodora mentioned earlier. Some of my research is in computational photography. These days, taking a photo with a smartphone involves AI. It's how the photo quality looks so good, even though it's taken with limited hardware compared to a DSLR camera. AI is penetrating into many fields, and more AI is coming, whether it's autonomous vehicles, service robots, the metaverse, or digital healthcare. The latter is something that I'm working on here at Queen Mary. However, the technology is moving faster than the regulation. In our rush to solve the world's problems with AI, we may be in fact creating new problems. Many modern AI systems lack transparency, explainability, and have potential to reflect biases. Whilst the technology itself is neutral, in my opinion, the deployment of AI can engender a number of issues that may violate fundamental principles that underpin our civil society. This brings me to human rights, which are fundamental rights that protect the dignity and worth of every person, such as the right to express opinions, right to privacy, right to be treated fairly by the state. There's a legal basis for these rights stemming from the Universal Declaration of Human Rights, the European Convention on Human Rights, and here in the UK, the Human Rights Act. The recently published UK National AI Strategy is pro-AI, but it recognizes the need to get the national and international governance of AI technologies right to encourage innovation, investment, and protect the public whilst also protecting our fundamental values. We're delighted to have this panel session today, just 2 days before International Human Rights Day on the 10th of December. We've invited an expert panel to share their views on AI and its repercussions on human rights. I'm thoroughly looking forward to an inspiring discussion today. And with that introduction, I'd like to pass the floor back to Theodora. Thank you.
Thank you very much, Greg, for setting the scene. So what we'll do now is our panel will answer some questions that myself and Fernando will pose to them. And after that, they will answer your questions. So please feel free to submit your questions at any point during our discussions using the Q&A function of Zoom. So what I'll do is I'll first introduce all the panelists and then we will start the discussion. We have Dr. Maria Pia-Sacco. She is Senior Legal Advisor at the IBA, at the Legal Policy and Research Institute, where she leads projects on business and human rights, and where together we're members of the IBA Working Group on AI and Human Rights. The working group has contributed to the work of the Council of Europe's Ad Hoc Committee on Artificial Intelligence, CAHI. She holds a PhD in Law and Economics from Erasmus University in Rotterdam, and also an LLM in Law and Economics from Bologna and Hamburg University. Second, we have Dr. Florian Ostman. He is the Policy Theme Lead with the Alan Turing Institute Public Policy Program. His focus is on regulatory innovation and the governance of AI and other emerging technologies. His recent work includes a report commissioned by the Financial Conduct Authority examining ethical and regulatory issues raised by the use of AI in financial services. In addition to his technology-focused work, Florian has a long-standing general interest in corporate responsibility and business and human rights. He's a member of the Royal Statistical Society's Data Science Section Committee and the Law Committee of the IEEE Global Initiative on Ethics of Autonomous and Intelligent Systems, and also holds a PhD in political philosophy from UCL and a master's degree in public policy from the Harvard Kennedy School. Thirdly, we have Professor Elspeth Guild. She is the Jean Monnet Professor ad Personam at Queen Mary University of London, as well at Radboud University in the Netherlands. She's also a partner at the London law firm Kingsley Napley. She's also a visiting professor at the College of Europe in Bruges. Her interests and expertise lie primarily in the area of EU law, in particular EU justice and home affairs. She also researches EU privacy and data protection and the nexus with human rights. And last but not least, we have Minesh Khanna. Minesh is a solicitor advocate and AI lead at Simmons & Simmons. He has experience of representing clients in both litigation and arbitration, and is also an accredited mediator. He has spoken and published articles on the topic of AI and is a member of the International Association for Artificial Intelligence Law, as well as the chair of the AI group at the Society for Computers and Law. So with those introductions, I am going to first move to ask a question to Maria Pia. I mean, when we think about artificial intelligence and human rights, a range of different issues come to mind. So what are the human rights issues that you've encountered in relation to AI?
Thank you, Theodora. First of all, let me just thank you also Dr. Barrio and Queen Mary University for the kind invitation. It's a real pleasure to be here today. Well, I guess as you've also mentioned in your introduction, AI really represents a great opportunity in general for our society and also for enhancing human rights and the protection of human rights. So I would like to begin with this assumption. We kind of appreciate the value and the positive value of technology. And as Professor Slabaugh said in his introduction also, technology can be also considered as being neutral. So what I'm going to talk about is the type of deployments or uses we have witnessed which have had also negative consequences or potential negative impacts on human rights. And I think this tension between the positive and negative impact of technology, innovation, and AI specifically has to be taken into account when talking about negative consequences, but more importantly, when talking about regulatory interventions, because of course, it has to be proportionate and it has to balance these two dimensions, positive and negative. When talking about negative consequences, the first aspect which should be considered is that, of course, there are different actors here. So there are AI providers, which can be developers, software developers themselves, but also private sector actors using AI. So probably Florian will talk about the use of AI, I don't know, in the financial industry. So we know that also private sector actors deploy AI for their business activities, but also governments have been using AI-based technologies for the provision of public services, including social welfare services. And I think this, the third dimension is probably the most difficult and possibly even dangerous one, because the use of AI by governments will affect a large number of citizens, but of course, even the use of AI by the private sector can affect a large number of consumers. So just to give an example, we have seen even like important cases recently. So the City one in the Netherlands by the Hague District Court in February 2020. So this decision was talking, it was about basically a system used by the Dutch government to identify a risk level of possible beneficiaries of social welfare services. And in this, through this system, the government was collecting health data or even data regarding compliance of these actors with the law. And they were all then through algorithms potentially associating this information with the level of risk with regard to the possibility of the funds, public funds being misused. So this specific technology was challenged by NGOs in particular, and the District Court of The Hague decided that the specific technology used by the Dutch government, even though was trying, of course, to achieve a positive objective, so the kind of reduction of risks with regard to fraud for social welfare services, it had also negative consequences and even potential negative consequences for, first of all, the right to privacy, but of course also the right to non-discrimination, in particular of vulnerable groups and groups which could have been regarded as kind of minorities. And I think this is quite important because the decision was not based on a specific violation, but just on the general assumption that the type of information that was collected and gathered was excessively broad, so non-proportionate. There was also a concern with regard to the lack of transparency of the way in which the algorithm would associate the risk levels to these actors. And of course, also one dimension which was taken into account, and rightly so, I would say, was the extent to which beneficiaries could have negatively affected by biases or even just errors in the analysis of the risk level. So I think it's also, as mentioned at the beginning of my intervention, it's about balancing different kind of social interest, public interest, so the interest of society to make sure that funds are not being misused, but also the interest of protecting minorities, the interest of making sure that minorities are not discriminated, privacy rights are protected, and also, of course, that people who are in need of social welfare services do not lose them just for errors or discriminatory behaviors. I will not enter into many other cases for the interest of time, but I would just like to say that some of these also uses or other types of technologies which can have a potential negative impact on human rights are also represented by cases in which the government intentionally wants to violate human rights. And these are, of course, extreme cases. We might probably talk about it, or I will definitely go back to these examples in my second intervention with regard to cyber surveillance technology. So we've seen autocracy misusing these types of technologies, and differently from the first example, in which, of course, the software could have led to discrimination, but in a kind of inadvertent way, there are also cases, and we have seen cases in which governments or even private sector entities have been using and misusing AI for intentionally violating and limiting human rights. So thank you, Theodora.
Thank you, Maria. Yeah, so they're highlighting the both intentional and non-intentional violation of human rights and the importance of proportionality and transparency and privacy. Following on from that, Florian, what are your views about human rights and AI?
Yeah, thank you, Theodora. And let me also start by thanking you for inviting me to participate today. So I think, as was mentioned at the beginning, AI has evolved to be a very broad term, covering a very broad range of different technologies, technology use cases, and as a result, also a very wide range of different risks and potential harms. So I won't attempt, I think it's very difficult to attempt to offer sort of a comprehensive, complete mapping of risks, at least within 5 minutes that I've been told I have right now. But I think I'd like to share sort of 3 focal areas that I think are helpful for structuring the problem domain, as it were. So 3 focal areas associated with different uses of AI, and as a result, different types of risks. And Maria touched on many of them already. I'll start with the one that perhaps hasn't come up yet. So the first area, I think, relates to the use of AI in the context of physical machinery or physical devices. So if you think about autonomous machines or different forms of automation, that could be in a production context, manufacturing context. It could be the case of autonomous weapons, for example. It could be autonomous vehicles or other forms of transportation infrastructure. I think the kinds of risks that arise in this context, or most prominent in this context, are risks to physical integrity, risks to life, and so on. So that's physical safety risks, broadly conceived. So that's one area. As a second area, there is the broad range of use cases where AI is used as a software product to analyze information and to make decisions, in many cases decisions about individuals, be it in the public sector or in the private sector. And so the example that Maria mentioned about welfare decisions would be a case in point here. I think in that area, the most prominent types of risks that arise and concerns from a human rights perspective are concerns about differential treatment, non-discrimination, access to opportunities, the satisfaction of basic needs, and so on and so forth. So broadly speaking, again, sort of concerns about how individuals are treated in society. And then as a third area, I think, and that's an area that covers both of the previous areas, because data is so fundamental whenever we talk about AI, is our data-related concerns about data protection, privacy, whenever personal data is involved in the development or operation of AI systems. So I think that's sort of one way to think about 3 particular prominent areas of human rights risks. I'd also just very briefly like to touch on the limitations of using a human rights lens in thinking about AI risks. Perhaps just to get that out of the way, since we'll be spending the rest of the afternoon talking about the human rights lens, thought it'd be worth mentioning that there are significant potential harmful impacts associated with AI that aren't quite captured by thinking about human rights as a framework. And I think there are 2 examples. The first one are potential negative impacts at a societal level that aren't captured because of the individual nature of human rights. So examples here would be, problems around misinformation in social media, electoral integrity. In the financial services sector, issues around financial stability when it comes to automated trading in financial markets, for example. So that's the case of societal level risks. And then there are also individual level risks that are ethically significant without rising to the level of rights violations or rights issues. So when we think about profiling and making decisions about individuals, there are all kinds of questions potentially about whether it's reasonable and ethically justifiable to use certain information about individuals to make decisions about them in cases where that information doesn't relate to legally protected characteristics, but may nevertheless be considered objectionable. You know, in the financial services context, simply because that's an area that I've recently focused on, there's so many aspects of our private lives that could be used, for example, for purposes of credit scoring, many of which may be thought of as quite intrusive without necessarily amounting to sort of a human rights issue. So those are two examples, I think, for the limitations of human rights. But yeah, let's return to the human rights angle, and I'll stop here.
No, that's great. Thank you very much, Lauren. So as you said, I mean, the uses of AI are so broad, and equally so are the potential impacts on human rights. I mean, it could be any human right that's impacted by AI depending on the use. And also very useful to broaden out and to say that it might not be directly human rights or indirectly, but the societal issues that you raise. Thank you. And on that, we'll turn to Elspeth. And Elspeth, what are your perceptions of AI and its impact on human rights from your expertise?
Thank you so much, Theodora, and thank you so much for the other speakers, because you've given me a wonderful platform to come at this from the legal perspective. And I think AI has been a terrible shock to the legal systems of most liberal democracies, because of course AI is a scientific tool which is finding all kinds of applications, many extraordinarily beneficial, but which of course has nothing to do with law. And so law only comes to AI when there's a problem, when something starts to go wrong. And because of some of the issues that have already been brought to the table, we're seeing things go wrong in a number of areas which raise human rights issues. I would like to pick up, though, particularly on something that Florian said, because when law comes to AI, there are two quite different ways in which people who consider something's gone wrong and AI is responsible come to the courts, come to parliaments asking for regulation. And one is really the consumer protection side, where AI has been involved in the development of toys, for instance, is a classic, which then harm children. So it's a consumer protection issue. And the other is the human rights angle, which we're focusing on more at the moment, though the two do overlap and intersect in ways which are quite complicated for law itself, because they're not really designed to overlap and intersect. And I think that we've had a bit of an outline of the human rights issues. What do human rights bring to the table, leaving aside the consumer protection areas, which are only really come into play if you're looking at economic and social rights, which are of course human rights, but I'll leave them aside for the moment. And the first, of course, is privacy. So we have a human right to privacy. We have a lot of discussion and debate, particularly after 2013 and the Snowden revelations, about do we have common standards across the world? Is privacy an internationally recognized concept in human rights law? And a very rapid development of the intersection of data protection as being the embodiment of the right to privacy, which is what is required of states. What must states do, which is data protection legislation, to protect the privacy of people? And that, of course, is a huge issue, because we have, first of all, the principle of consent. Your data, personal data, cannot be used without consent, and that has to be informed consent, and the duty not to use data for a purpose other than that for which it was collected, and the obligation to erase data once it has been used for the purpose for which it was gathered. And that creates a whole series of tensions in the AI field because of course, AI depends on data. Now, if it's data about mountains and earthquakes, that's not personal data, so it doesn't matter. But an awful lot of data is personal data. And indeed, the treasure troves of personal data which are collected on the internet become a bit of a battle site between the ways in which they can be used for all kinds of AI purposes for commercial reasons, and this whole question of privacy, duty to erase data, etc. In that context, we have two other issues which arise, both of which have been referred to. And one is, does AI amplify the risk of prohibited discrimination? So there are lots of grounds on which discrimination is completely lawful. There's lots of areas where distinction between groups of subjects is not discrimination because they're differential. It's not treating the same people differently. It's treating different groups differently. But the problem with a lot of AI tools is that in their design, intentionally or unintentionally, the outcomes end up being discriminatory. And there was a recent case of that in the UK on the use of AI in making visa application assessments in Nigeria, the foxglove litigation. Then there's the question of freedom of expression. And we're much more, we're very familiar with that in the context of what can people say and not say, and what is hate speech, and who should be protected, and who's responsible. And here we've almost created a cottage industry within the big platforms of lawyers who are trying to make these kinds of decisions without the democratic authority of governments to determine what are the limits of freedom of expression. And of course, the third big category is procedural rights. So an individual says, I have suffered harm as a result of the use of this AI tool. For instance, my visa application was rejected and I'm a perfectly acceptable person now to get a visa. And the black box effect that the AI tool and the way in which it operates is protected by a whole series of course, commercial interests, but also is inexplicable or maybe inexplicable to a judge. And therefore the capacity to get an appeal and a fair consideration of the case are hampered because the decision is not explicable in a format which is accessible to the legal world. So these are, I think, the big issues which we're trying to deal with and we're trying to grapple with and we're trying to find solutions to. And I think I've gone over time. It's very kind of you, Theodora, not to have cut me off already.
No, it was very interesting. I mean, yeah, we're covering a lot of ground here. So here we've introduced the issue of privacy, the fact that outcomes are potentially discriminatory, the democratic deficit that exists, the impact that it may have on a fair trial and therefore also access to remedies. So yes, we've covered a lot, but I'm sure Manish has even more to add to it. So Manish, I'll hand over to you to share your experience about AI and human rights.
Thank you, Theodora, and thank you for giving me the opportunity to speak today. And what I'm going to talk about follows very nicely from what Elspeth has been talking about, in particular in relation to privacy and artificial intelligence. Now, let me take you back to 2017. In that year, the South Wales Police, the police force responsible for governing in South Wales, started using facial recognition technology. And it was using facial recognition technology to try and identify individuals on watch lists, i.e. potential individuals suspected of committing criminal offences. Now, that use of facial recognition technology was challenged in the English courts. And the decisions of the English courts are significant, I think, because as far as I'm aware, they are the first example in which facial recognition technology has been challenged judicially anywhere in the world. And they were the first time in which AI has been challenged on the basis of a breach of human rights law. And I should add another significant point. It was the first time in the UK, certainly, that the Court of Appeal in this case found that there was a breach of human rights law from the use of AI. Now, for those of you unfamiliar with the case, a challenge was brought against the South Wales Police on the basis that it was using this technology, which essentially comprised a video camera mounted on a van, scanning faces at public events, for example, football matches, and alerting the police when there was a match to someone on the watch list. Now, an individual by the name of Mr. Bridges brought a challenge against the South Wales Police on the basis that this was an unlawful use of technology. Now, Mr. Bridges was not someone on the watch list. He was merely an innocent person, but his data was used because his face was being scanned. And even though he wasn't identified to someone on the watch list, for a split second, his data was processed, stored, and identified by the technology as not being someone on the watch list. And he brought that challenge on the basis of both human rights law and data protection law. Now, the Court of First Instance, the High Court, rejected his challenge. It decided that the use of facial recognition technology by the South Wales Police was lawful. Now, Mr. Bridges appealed that decision, and it's the Court of Appeal's decision which is really of interest. And the Court of Appeal accepted that appeal on 3 different grounds. Now, 2 of those grounds were data protection related and public sector equality duty related, but it's the 3rd ground that related to human rights, and that one which I want to focus on for a moment. Now, Mr. Bridges said that the use of facial recognition technology by the South Wales Police was in breach of Article 8 of the European Convention on Human Rights. Now, those of you who are familiar with that is the right to respect for your private life. Article 8.1 sets out in very clear terms that everyone has the right to respect for his private life. Now, Article 8.2 is the one that falls under the radar somewhat. Article 8.2 says, there shall be no interference by a public authority with the exercise of the right to private life, except as is necessary in a democratic society and in accordance with the law. Now, in the High Court, the first instance decision, the court considered that capturing, storing, and processing biometric data triggered Article 8. That was, the court said, an interference with your right to respect for your private life. That was so, even though, as I said, in Mr. Bridges' case, his data was captured only momentarily and then ignored by the technology because Mr. Bridges wasn't on any watch list. Now, that is a significant finding, and it wasn't considered on appeal, so it may fall under the radar. But it's significant because many forms of AI are likely to capture, store, and process personal data, including biometric data. So the court's finding that Article 8 was triggered in this case is significant for public authorities using or thinking about using AI. But the key point for the Court of Appeal was whether the South Wales Police had a legal basis for using facial recognition technology in the way it did. As you recall, Article 8.2 says, no interference by a public authority with the Article 8 right, except in accordance with the law. Now, the South Wales Police said, there is law. There is law that allows us to use this technology. But what the Court of Appeal said was that that law didn't specify in enough detail who could be subject to the technology and in what circumstances it could be deployed. The Court of Appeal effectively said there was too much discretion left to the police, and there was therefore a breach of Article 8 of the European Convention on Human Rights. So just stepping back a moment and considering the implications of that case. Well, the implications are many for public sector authorities. There are human rights concerns with public sector authorities using facial recognition technology and perhaps even artificial intelligence more generally. Now, stepping even further back, we say quite often that AI is not really regulated at the moment, and I think there's some truth to that. But what this case shows is that if you really want to challenge the use of AI, you can find legal bases on which to challenge it. And Mr. Bridges, in this case, found a really sacred area, human rights law. And even though it was sort of a technicality, It's not as if the court said that this was a core breach of the right to respect for private life. It was more in the application of the detail and the machinery around Article 8. This was still a significant finding. The use of facial recognition technology was in breach of human rights law. And so I think this will encourage others in the future to find similar arguments to challenge AI use, especially by public authorities, based on human rights law. So if you ask me, I think this will be the start of quite a few similar challenges we'll see against the use of AI in the future.
No, thank you very much. I mean, that was very useful to show how the courts apply the human rights to artificial intelligence. Thank you. And on that, I'm going to hand over to Fernando for his questions.
Thank you, Theodora, and thank you for all the very interesting previous presentation. So now that we have set the stage up to what are the challenges in the relationship between human rights and AI, I think it's time we start to consider, okay, how we move forward. What are the potential solutions, legal and practical, for this conundrum that you have explained? Let's start almost with the same order. Maria Pia, what are your views on what are the potential solutions, taking into account what you mentioned before of the need for balance, and also that there are some AI technologies that might be actually enhancing HR enjoyment?
Thank you, Fernando. I mean, difficult question, we know. But first of all, I would like also to thank Minesh for his presentation, because what I did fail to mention is that even the decision of the Dutch court was based on the violation of Article 8 of the European Convention of Human Rights. So as you said, there are different entry points, especially when it comes to access to remedies, which can already be triggered without coming up with a new regulation. Having said so, I think, Fernando, your question is particularly important when it comes to prevention. So I'll try to focus on prevention. And from that point of view, I think we don't have kind of adequate tools and adequate frameworks in place. But what we have seen over the past few years is, first of all, a shift from an ethic-based approach to AI to a human rights approach to AI. So I agree with Florian when he says that some perhaps human rights cannot capture everything. So there are also concerns related to democracy and rule of law. And I know that the Council of Europe, at least in the work of the ad hoc committee on artificial intelligence, has tried to capture this three dimension, talking about the impact of AI on human rights, rule of law, and democracy. But I do think that at least focusing on the human rights implications of AI represents a step forward in the right direction, because it kind of pushes the private sector as well as the public sector to go beyond voluntary measures and voluntary mechanisms, and to think about mandatory mechanisms in which perhaps even sanctions are considered. So I'll try just to flag a couple of examples with regard to developments in the EU. And I would like to focus on one dimension, which is the human rights due diligence approach. So just to clarify what I mean by human rights due diligence, I would like to say that I'm referring to the framework established by the UN Guiding Principles on Business and Human Rights, whose anniversary comes actually this year. So it's the 10th anniversary this year. And I would like to say that basically in the three pillars developed by the UNGPs, in particular, the second pillar focuses on the role of the private sector in protecting human rights and remedying also human rights, obviously, when it comes to the third pillar. And this can be done by the private sector, even in the absence of mandatory mechanisms, just through the implementation of a human rights due diligence, which can be defined as a process through which companies can identify, mitigate, and also remedy risks of adverse human rights impacts associated with their activities. This human rights due diligence process has also been adopted by AI or technologies kind of companies in general on a voluntary basis over the last few years. But interestingly, in the very last few years, a reference to a human rights due diligence approach has also been made by regulators. And this is where what I'm going to focus on. So first of all, the European Commission's proposal for a regulation of AI. And we know, for those of you who are familiar with the regulation proposal, that the EU Commission has basically identified 4 levels of risks. So basically, it has kind of looked at AI-based technologies and divided these technologies on the basis of 4 potential levels of risks these technologies can lead to. The first level is what they define as unacceptable risks, and therefore kind of technologies which will lead to an unacceptable level of risk, of course, should be banned according to the European Commission. Now, interestingly, and this goes also back to Minesh's point, among the unacceptable type of risks technologies, we find social scoring, which is something that was discussed in the Hague Court, but also biometric identification in public spaces, with some exceptions. The second level of risk is high risk, basically technologies, and those technologies should be subject to a risk assessment, so a risk-based due diligence. The third level of risk is a kind of more limited risk, and for these technologies, companies are required to be more transparent with users about the fact that artificial intelligence is being deployed. And the final category is minimal risk, which according to the kind of current draft proposal should not be subject to regulations at all. Now, what I'm trying to say here is that the proportionality I've introduced in my first intervention can probably be achieved through a risk-based approach to regulation. And if the European Commission, for instance, identifies for level of risk, it means that depending on the level of risk we are talking about, different measures can be adopted. So from that point of view, I believe that this is a more proportionate approach to regulation. However, I think it's still insufficient, especially if we look at the proposal of the European Commission through the lenses of the UN Guiding Principles on Business and Human Rights, because we know that the risk associated to business activities is something dynamic, which can change depending also on the context in which these technologies are being deployed. I've spoken about cyber surveillance technologies, and we know that, of course, the same technology, as Professor Slabaugh mentioned at the beginning, can be risk neutral, let's say, but then the level of risk really changes depending on, let's say, whose government is using, what kind of companies are deploying it and for what. So I believe that even though the European Commission's proposal is it's a very good step in the right direction, it's still insufficient because it kind of is too static. So it can be actually too restrictive for some technologies. So some technologies might be banned no matter what. And for other technologies, it might be insufficient precisely because it doesn't consider this dynamic element of due diligence and the dynamic element also and nature of the level of risks associated to AI-based technologies. I would just like to add very briefly a comment on also an additional development which we have seen also in Europe, and I believe it's quite interesting, and it's with regard to dual-use items and export control ban on technologies, among which also cyber surveillance. So in the regulation regarding also dual-use items, this is basically a trade measure. So like companies exporting cyber surveillance technologies outside of the EU might be required to be subject to a specific authorization by competent authorities of their member states, depending on what kind of risks can be associated to the use of this technology by governments or let's say consumers in the country of destination. And interestingly, even this regulation refers to due diligence. So all I'm saying is that I think due diligence can be a good solution to find proportionate measures, but then in order for this to be effective, it has to take into account the dynamic nature of risk.
Thank you very much, Maria Pia. Florian, you were talking about risk and harms, and you went beyond what the pure algorithmic, and you were talking about physical machinery and software and AI and software. So how do you see that those risks and harms that you identify? So how we move from there to a potential solution that could be regulation and could be other.
Yeah, thanks, Fernando. So I think there are two levels to that question that I would like to briefly comment on. The first one is, what are the governance levers or mechanisms that might be used? And Maria touched on some of them, such as human rights due diligence measures or human rights impact assessments. And then secondly, there's the question, what needs to happen in practice to make those measures effective? So if a company is required to conduct a human rights due diligence assessment, what is needed to make that successful? So just briefly on the first question, what governance levers might be used? I think what's very encouraging is that there's a lot of activity at the national, at the international level, at the European level in thinking about these questions. And Maria gave a good summary of some of the activity at the EU level and the level of the Council of Europe. We also know that in the UK, as part of the national AI strategy, the government has committed to developing a national position on how AI should be regulated with the white paper that has been announced for next year. So there's a lot of thinking going on. I think part of the challenge as a result of that is that given that there's so much activity, there's a challenge going forward in ensuring that there is coherence between different proposals and different mechanisms that are being developed. And so there are different, I think, three levels of, or three dimensions of complexity. So first of all, there's the issue that there are mechanisms that are developed at the national versus the international level, and the need to ensure coherence between those. Secondly, there is the challenge that, as we've discussed, there is now a significant activity that considers human rights focused cross-cutting mechanisms. So, governance levers such as a mandatory human rights due diligence assessment that aims to cover all human rights areas. But at the same time, there are also existing regulatory domains that touch on certain human rights aspects already. So obviously, one example would be data protection regulation or equality law in the UK. And so there's a question, how do we marry those existing issue-specific rules and regulatory frameworks with more general human rights focused frameworks? And then as a third dimension, there is a complexity between, on the one hand, having frameworks that try to cover all AI use cases, that we might call horizontal frameworks, versus governance frameworks for specific use cases or specific sectors. So we know in several jurisdictions, for example, there have been proposals specifically to regulate facial recognition technology as a specific legislative proposal that stands alongside proposals such as the EU AI Act that aims to cover all possible uses of AI. So as a result of these different dimensions, enormous complexity, and I think if we are to end up with a governance landscape that's meant to be effective and also sufficiently easy to navigate for developers and users of AI systems, you need to make sure that there is coherence between them and a certain degree of unity across these dimensions. So that's the question of governance levers. Now, just very briefly on the question of what are the practical challenges of ensuring the responsible development of AI systems and technologies. And these basically exist regardless of which governance framework one uses. I think the first challenge that's quite significant at the moment is that a very foundational precondition for managing risks is the availability of information about AI systems. And that is information across the whole life cycle of a system, from the initial stages of designing it, developing it, deploying it, and so on. And that information currently is often quite hard to access, in part because it's often not recorded. There are no standardized ways of recording them. And also because the supply chain of technologies is often quite complex with different suppliers, data providers, developers, companies that buy systems from providers. There's certain fragmentation that means that information is often difficult to access. So that's one challenge that needs to be addressed, coming up with ways of making sure that there is documentation in standardized and consistent ways, and information is available when needed. A second challenge, I think, is around competence of both users of systems, but also if we think about the procurement of systems and companies that use a system buying those systems from third-party providers, being able to make informed decisions about whether to buy a system or not. And I think there's a challenge around the information asymmetry between different parties in supply chains, but also differences in expertise. And of course, part of the challenge is that insofar as organizations rely on external providers, they may, as a result, not have the internal expertise to be able to assess the systems that they end up using. And so they need to trust the provider in terms of what the assurances that the provider provides them with. So that's sort of the competence aspect. Thirdly, I think it's clear that there is a certain need for independent verification and assurance in the market for AI systems. So what we've just said in terms of information being available, users being competent, that's all very important. But I think in addition to that, in many areas, there will be a need for independent forms of auditing, for example, or certification to come in to provide an independent voice and criterion of assurance to provide a basis for public trust that goes beyond what users and developers themselves sort of proclaim about the systems. So the independent assurance case. And then finally, and I'll keep that very brief, there is an important question around accountability and remedy if things go wrong. And I think there are important questions that need to be resolved that aren't always clear at the moment around liability, especially where supply chains are complex, but also users and deployers of systems simply having structures set up that make sure that affected individuals have access to remedy, sort of to think ahead of what that requires and to be able to respond to those kinds of cases.
Thank you, Florian. I'm not trying to use Florian's speech to do the Queen Mary pitch, but with competence problems, I think the university will be properly suited to advise on that. Minesh, you were talking about the privacy the violations in the breached case, and your conclusion was somehow like, everyone get ready, because the same way that breaches found a way to get against this technology, others will find. So what will be the way forward for this? So what different participants, both those potential claimants and the vendors, could do in order to ensure that this situation gets somehow balanced?
Yeah, well, let me come at it from the vendor perspective, because we're dealing then with organizations that I tend to work with on a daily basis in my job. And I'm going to very respectfully slightly disagree with what Florian said about access to information. I completely agree that there are limiting information sources when it comes to AI, but it's very important that we don't use that as an excuse, and organizations don't use that as an excuse to implement really good governance around AI. And I'm going to give you one key word that I think is important here, and that's knowledge. And I don't mean knowledge of human rights law, knowledge of customers, or knowledge of the supply chain. It's knowledge of the AI system you're using. Because what's happening at the moment, and this comes back to a point that Greg made at the outset, is that artificial intelligence as a technology is being adopted and used at an increasing rate. The development of the technology is phenomenal. Greg mentioned deep neural networks. The things that they can do are absolutely unbelievable. But what's happening is that the use of technology and its development is outpacing our understanding of it, and of course, regulation of it. And in practical terms, what I'm finding is that there's a disconnect in organizations between those who are deploying AI systems, whether that's your tech, IT, commercial teams, and those teams and organizations that are responsible for protecting the organization and looking after risk. So your risk, compliance, legal teams, those teams are not aware of the risks. They're not aware of the human rights challenges that could be brought. And this is principally because, and I say this with respect, they don't properly understand and know about the technology. Now that's understandable. The technology is complicated and innately it's opaque. We've heard the word transparency and explainability mentioned. That's all about the fact that a lot of AI does operate within the black box. And as humans, we can't always understand how it works. But in order to mitigate risk, you need to understand risk. And in order to understand risk, you need to understand the thing that's capable of causing the risk, in this case, the AI technology. And as Maria said, that risk is also dynamic. So for me, at the moment, what organizations need to be doing more of to understand and mitigate this risk, including the human rights risk, is to play catch up in terms of understanding and knowing how the AI technology their organizations are using actually works. And that's about explainability, transparency. It's about encouraging organizations to actually start to think about their AI, to ask the questions of their technical IT teams, and to start really understanding and make sure they understand how their AI technology works. Coming back to the South Wales police case I mentioned, it's interesting that in that case, the court was critical of the South Wales police because they didn't understand their own AI very well. They'd asked questions of the developer of the technology, but perhaps not enough questions. So put yourselves in the shoes of the legal advisors to the South Wales Police. They're responsible for protecting the organization, ensuring it doesn't do anything unlawful, including using AI. But how can they be expected to do that when they don't have a full understanding or full transparency around how the technology actually works? Now, if we get back to the real world for a minute, this all sounds all well and good. I'm me saying to organizations, you need to start learning about your AI systems and make sure you understand them. But how does that happen in practice? And it's a point that Florian made. It's about governance, and that starts at the top. What we need more of is senior managers, board members being alive to the risk of AI, and then encouraging processes, protocols, communication lines, accountability structures within their organizations to ensure that everyone understands how they're using AI and how that technology actually works. And I'll finish by just mentioning that the FCA released an interesting paper back in 2019 now about this point. And they said that as a regulator in the financial services industry, they are going to expect board members to be able to explain and understand exactly how their organization is using AI. It's not going to be sufficient for people to say, well, it operates in a black box, or my IT team understand it, but I don't understand it. That's not good enough. Why? Well, because AI, as we've seen, is capable of causing harm. It creates risks. And so organizations need to start taking steps now. And for me, that starts with knowledge. And I do understand there is a shortage of information about how AI works. It is very complicated. But for me, the priority for organizations is sitting down and working out how they can understand more about the AI technology they're using. And once they understand the technology, then they can assess risk. And when they can assess risk, they can then move to mitigate that risk.
Thank you, Minesh. And to close this round of looking forward, we have the privilege of having LPS, Professor Gill, who is both an academic and also works and has a foot on a law firm. So therefore, we have both the practice and the unique way of thinking of Professor Gill. So LPS, please, the floor is yours. And how do we move these ideas forward?
Thank you so much, Fernando, and thank you very much to everyone on the panel for having developed these issues. And I think we've seen the difficulty of regulatory absence in the UK, where we've had a number of court cases and scandals of one kind and another through state use of AI tools. The post office case, of course, was one. The AI used to determine whether or not foreign students were cheating on their English language tests was another. We've had a series of these, which, of course, this kind of litigation, which ends up reflecting very badly on the lack of regulation, but also on UK companies developing AI tools. Almost all of the issues that I've spoken about are ones which engaged very profound fundamental rights issues. The post office case, of course, resulted in a number of post office managers being who'd been accused of fraud, committing suicide, the foreign students fraud in English language cases resulted in hundreds of thousands of pounds of lost fees and lost futures for young people, etc. The Foxglove litigation, which didn't get to court because the government promised to withdraw the AI tool before putting it into force. This very active litigation does no good for the UK's reputation as an upholder of human rights, and does nothing for business in the UK that's trying to build and develop AI tools. And I think it's for this reason that Maria and I have both been pretty focused on what the EU is doing, because of course they're the first regional group, or government indeed they say themselves, which has sought to present a regulation on AI. And Maria's given us pretty much the outline. Now, there are a number of things which we need to think about in terms of the way in which the EU is proposing to regulate AI. And the first is it's chosen to go down the route of risk-based analysis. So they will use risk-based theory to, as they've done, to present a system of regulation. And there are certainly many critics out there about risk-based regulation, that perhaps this is not the best tool. The second thing that I would say about this is that, notwithstanding the very numerous references to fundamental rights in the AI regulation proposal, one of the big difficulties is how to put that into practice. And here I think Florian's comments about what kinds of systems do we need, what kinds of oversight do we need, is one of the problems which the Commission tries to deal with by using the European Data Protection Board and the data protection system as being the overarching one. It already, of course, has its roots deeply in all of the DPs in the member states. So that's quite helpful in terms of the privacy side. But then you need the consumer protection side, where it seeks to bring that in, but under the privacy angle. And the system of regulation which they're proposing is one which is going to need quite a lot of additional resources, both at the national level. In some member states like Germany, it will be at the regional level, also at the EU level, if it's actually going to succeed. And as Maria mentioned, there are quite a lot of civil society actors concerned about human rights that are unhappy about the risk-based approach, in that this may capture the wrong groups or not the right groups. And in answer to Florian's comment, in the annex to the proposal, risk is also based on sector. So there are sectors that are, by definition, sectors of risk of causing harm. Online gambling is, of course, one which a lot of people are concerned about. And I've already mentioned the use of AI in the development of medicines, which is another. So I think we need to look more closely at, is this structure actually going to deliver on the human rights? What we want to do is to reduce the risk of human rights violations in the development and use of AI tools. We want to have systems which are sufficiently robust, so we're not having the problem of the negative externalities to the United Kingdom, of being the constant butt of judgments where AI is found to have been in violation of human rights. And I think that to do this, we're going to need also to work very closely with our colleagues and allies in the European Union, because as we're seeing in a number of fields under the EU-UK Trade and Cooperation Agreement, exchange of data is vital to this sector. If data doesn't flow, then the UK is going to be squeezed out of this market. So I think that getting the human rights angle right is of key importance, but it has to be in tandem with what our biggest neighbors are doing. Thank you very much.
Thank you, Elspeth. Couldn't be clearer, and the perfect ending for these two sectors. Now we are going to try to moderate and curate some of the questions that we have received. And I think that Theodora is the perfect person for that.
Yeah, no, happy to. And thank you everyone, for the whole panel, for all the comments so far. And thank you to our participants for the questions so far. Please keep them coming. I've curated 3 that I'm going to put out there for anyone to answer. The first one is from Hend, and it concerns AI biases. So the question is, how can the legal system deal with biases that exist within AI? Noting, of course, that artificial intelligence is not the only one with bias, but that human biases also exist. The second question was, how can the EU export rules have any effect when the EU is at best a second-tier player in the AI industry? And the third one came from an anonymous participant, and the question is, how should industry, including universities, decide how to work with countries who use artificial intelligence for intentional human rights violations? It's a bit of a political one to end there. So I'll open up the floor. I don't know who wants to deal with which question. So who wants to go first? Minesh, you've unmuted. Is that an indication?
Yeah, I'm happy to go first, mainly because the second and third questions are really difficult. So I'll leave those to the experts. Bias is something I'm writing a couple of chapters on for a couple of books at the moment on AI, so I can talk about that. The first question was comparing the bias of humans with the bias of computers or AI systems, and I think that's a really valid point. Sometimes I'm critical of the fact that we seem to hold AI to a very high standard. More so than we do humans ourselves. So when an AI system goes wrong or causes bias, we're all up in arms, but we're not doing as much, in my respectful view, when humans are clearly capable of causing discrimination through their own unconscious or conscious biases. So I do worry that sometimes we hold AI to too high a standard. I can understand why we do that. It's important in the infancy of its development, why we expect big things from it, to test it and make sure it's right, but I do worry about it. The second point is we must always remember that many of the biases that AI presents are in fact just a manifestation of human biases. When we hear about examples like Microsoft's chatbot Tay, which ends up causing harm and discrimination and effectively being racist, we've got to remember that's more a reflection on people rather than the technology itself. In terms of how the law can deal with bias, that's one of the areas where we do already have some regulation and some law around this. Most jurisdictions have anti-discrimination legislation. In the UK, we've got equalities legislation. So in theory, we should still be able to prosecute discriminatory uses of AI where it's causing discrimination. But I think actually we're probably moving to a need where we need specific legislation to deal with discrimination caused by AI. And really what we need to do there is tackle the causes of discrimination in AI systems. So we need regulation about the way the data sets are collated, the way that AI systems are trained, and the draft EU regulation goes some way to doing that. It actually contains very onerous obligations around data. So I think we've got some law, probably not enough law, but let's always remember that actually humans probably have a bigger problem with bias and discrimination than AI systems.
Maybe if I can just come in on the same question, I think that's where I'm probably best placed to comment the bias question as well. So I think on both of those questions, the first question was, I'll take them in the same order, are we holding AI systems to a higher standard, and should we? So at one level, I think there are reasons why we may want to hold them to a higher standard. And one of them is that in many cases, a single AI system may have a much wider affect the fate of a much larger number of individuals compared to a biased individual human decision maker, right? If you think of a credit scoring algorithm that's used across an entire bank's services and international operations, the impact is going to be much bigger if that system is biased compared to individual human decision makers making biased decisions in individual branches, say. So part of me, I think, is inclined to say, yes, there are reasons, at least in certain contexts, to hold systems to a higher standard. But the other thing I'd say is that insofar as we think we shouldn't hold them to a higher standard, the reason that we're now focused on these discussions, and discussions of bias are so prominent in the context of AI, shouldn't lead us to conclude that that's exaggerated or misplaced. It should rather lead us, in some cases, to question pre-existing practices in cases that don't involve AI, and think about, why certain, as I think the person who asked the question mentioned, why questions of bias had been neglected in the past. So we should sort of use the moment that we're in terms of public discourse to raise awareness for questions of bias in decision-making across the board, including in cases that don't involve AI, rather than saying, because we haven't cared about bias in the past, we're not going to care about it in the case of AI. So that's my take on this question of potential double standard. And then very briefly on how the law should deal with questions of bias. I think one of the challenges generally in discussions of bias is that the term often isn't very well defined and also has different meanings in different disciplines. So, in psychology and statistics, in the legal context and social sciences, bias as a term has different meanings. I think it's often useful to use alternative terms, such as, that are better defined, such as unlawful discrimination, indirect discrimination versus direct discrimination, and so on and so forth. So I think there's a lot to be gained from trying to be as clear as possible on what we mean, and distinguishing between cases, for example, where there is an empirical basis for differential treatment, but we think that's inappropriate legally because the characteristics are protected. But there is sort of a foundation for the decision, compared to cases where the empirical foundation is off and the data that grounds the decision is biased, and therefore there's something wrong with it. So because the solutions to those two scenarios is going to look very different, right? In one case, it's about fixing the data. In another case, it's about ensuring that certain variables don't affect the decision outcome. So yeah, conceptual clarification, I think, is part of the solution.
Thank you, Florian. Elspeth, you want to tackle one of the questions?
Yes, I do, but I can't resist just adding to what Minesh and Florian have said on this question of discrimination. And I think poor AI in this context, I mean, it's trained on past decision-making. So AI has an inherent part machine learning. So it's fed in a whole bunch of previous decisions, and then it spews out what it sees as being what a decision maker would want to make. And there's nowhere where this was more evident than in the year before last clearing decisions for university entrants, where all hell broke loose because the AI tool had been trained on all the past decisions. And it said, oh, so you want the young people who are coming out of fee-paying schools to go to Oxbridge, and you want everybody else to go somewhere else. And as soon as the results came out, they had to go back and redo it all, because of course you can't just say that, even though the AI was, perfectly respectably just reflecting what the machine learning of the data on which it had been trained. But I wanted to deal with the third question of industries and what they should do about working with countries which are intentionally using AI tools for purposes which contravene or violate human rights. And I think here we have a very easy solution to this problem that we use in terms of military hardware. So we have the whole question of export licenses. You cannot export military hardware to countries which have bad human rights records. We have a whole hierarchy of this, certainly in the European Union and in the UK. And if we go down the same route as the EU on the AI regulation, and we're talking about risk, then one of the risks that will have to be dealt with in the risk scoring of different kinds of AI will also have to be reflected in what will be subject to an export license and what will not be subject to an export license. So I don't think this is rocket science. We do this in a variety of other areas, even in dual use materials with military potential. And I think we can quite easily apply it. I'm not saying that the existing situation is perfect. I'm just saying that we do have a basis on which we can work. And in terms of EU export rules and second-tier players in AI, I think this is really a question about globalization and protectionism, but I'm not entirely sure how I would answer it. I'm not sure. I think perhaps someone who has been working perhaps more in the financial field will be in a better position to look at this than I am from a purely human rights angle.
If I can jump in and add to what Professor Gildas just said, first of all, I mean, the difficult political question regarding the way in which we can reduce the risks of adverse impacts with regard to the use of AI by autocracies. I will say I totally agree with Professor Gild. So I believe trade measures in general are powerful measures. We have seen import bans with regard to supply chain and the Uyghur situation being implemented by the US. And I think the equivalent of that, it's export bans for dual-use items. And as mentioned, the EU has planned and has also recently introduced a regulation allowing for cyber surveillance technology to be regarded as one of those subject to dual-use item regulation. I think this regulation is insufficient because it kind of doesn't provide a clear list of items which can be banned per se, but it kind of subjects them to an ongoing due diligence. And, you know, here we go to due diligence and risk-based approach again. So governments and national authorities, as well as the private sector companies involved in the development of these mechanisms and technologies have to conduct an ongoing assessment of the level of risks associated with the export of these types of technologies. And there is a kind of voluntary measure there, which makes it a bit weaker, because it's like, you know, if companies find out after having carried out their due diligence their technologies are potentially leading to human rights violations, then they should be the ones informing their regulatory bodies, and the regulatory bodies have therefore decide whether the export has to be subject to authorization or special waivers or not. But so even though difficult, I think this is one way. And in terms of many EU companies being second-tier suppliers, I think not all of them. First of all, there have been instances in which they were kind of, you know, first-tier companies, and I think even if we consider them as, you know, being smaller suppliers or part of the bigger chain, I think if we also look at the UN guiding principles, certainly we can infer that the responsibility of companies to be aware of the risks does not only entail them to look at their supply chain, but also at their value chain. So they have to be aware of the risks associated with their end users and not only with their suppliers. So I understand that this is, again, quite challenging, because some of these companies might not have the adequate resources to conduct their due diligence. But sometimes it's not really rocket science, because if you know you are kind of working for a specific piece of technology, which will be then added to cyber surveillance technologies exported to very high risk countries in which kind of dictatorship or like minorities are being persecuted, then you know that there are high chances of these being misused. And it's about then, what do you do, whether you want to kind of, you know, turn a blind eye, or you want to be open and trying to really be proactive irrespective of the regulatory framework. And I think the answer is about governance, as Minesh was saying. So yeah.
And Marika, on that, there was another question which I think fits into what, or follows on to what you were saying, which is what can an organization do at the onset of implementing AI? What can they do to mitigate risk? So what's the recommended method? And I would say it follows on from what you were saying about the due diligence.
It follows on from the due diligence, but as Professor Guild was saying, the risk-based approach, it can even be detrimental if it's regarded as a static process. Because if we come up with a list of high risk and low risk, we keep it as it is, then it becomes dangerous because it's not proportionate enough for even potentially positive impact to be considered, but also for potentially negative impact to be regarded if things change. So the due diligence is definitely a good tool, but it has to be regarded as a dynamic tool. It has also to, I guess, include the involvement of stakeholders. So I think the lack of information and the difficulty with regard to the lack of transparency and opacity of this technology can partially be overcome if companies work with stakeholders, which will also include NGOs, civil society organizations, and even experts, engineers who really work on this technology and develop the technology. So it's something that companies can come up with if they work together with other stakeholders, even with competitors in a kind of multi-stakeholder way. And we have seen these happening already in other sectors outside of the technology sector with regard to the use of due diligence for a supply chain, for instance, with regard to modern slavery risks. And I can promise Florian and Minesh that, the same point about, the impossibility of understanding the risks associated with the suppliers on the ground for companies based somewhere else, it's not as opaque as algorithms, but still, companies will claim that this is impossible. But I think, if you are really serious about reducing the risks and if you work with other stakeholders, it's probably going to be a big improvement also for human rights defenders and victims in general, rights holders.
Thank you very much for that. And Greg, did you want to answer that question?
I just wanted to follow up on the great things Maria was saying. I totally agree with all of that. I just wanted to say from like a technical point of view, it's very good as an AI developer if you can audit your data. So, these algorithms are learning from data, they're learning the biases from the data. And I think there's been some deployments where computer scientists have taken data sets that have bias and then they make biased AI algorithms. So there's kind of a garbage in, garbage out effect. But auditing the data, I think, is very important. And also what Maria was saying about sort of continuous assessment, because these algorithms are designed on a data set. There's kind of certain assumptions that go into that data set, and the algorithms start to become brittle when you put the algorithm into a different context. So I think it's quite important to monitor the performance of the algorithm through time to make sure it's delivering the expected outcomes. Thank you.
Thank you. And the final question I'm going to put to you, we have 5 minutes, so a minute each of you each answer. Dominic's question gives us the opportunity to end on a positive. And so he wants us to discuss or talk about the positives of AI. So he says, can AI systems, for example, be used to monitor the state and hold it accountable, or detect discrimination, or determine whether measures to reduce social harms actually deliver? So the question that I'm going to pose to you is, can AI be used to help promote and protect rights? So who wants to go first?
I don't mind taking that first. I think what I would say is that AI is increasingly being used in the judicial sector, and it can be used in that sector to increase access to justice, potentially promote the rule of law, and otherwise make justice better, for want of a better word. We've got to be careful, of course. AI can't be allowed to do too much, like replace judges and actually be responsible for making judicial decisions which could impact upon people's liberties and other rights. But it certainly can improve access to justice. I heard of an example in Colombia, I think, where the Colombian Constitutional Court receives hundreds of complaints a day about fundamental rights, and it's difficult for the courts to actually process those. They now have an AI system which is able to review them and prioritize the the highest priority complaints, for example, those which relate to access to health, for example. So that's one example in which AI can certainly do good.
Great, thank you. Elspeth?
Yes, I mean, I would say absolutely. I mean, AI is an amazing tool. Every time I go onto the internet and I try and search for something, if the AI tools are operating, the chances that I'm going to find what I want rapidly increase dramatically. I mean, all of us are dependent increasingly on AI working well. I think what we need to identify and regulate is where AI can give rise to discriminatory outcomes, for human rights abuse outcomes, and that's where we need to put our energy, but certainly not to attack AI in principle, which has an immense number of positive outcomes for us.
Thank you. Florian, 30 seconds.
Okay, very briefly, I think, yes to all of the above. I mean, clearly AI has so many potential benefits across all areas of the economy, including in the public sector. The only reason we haven't touched on those is the focus of this webinar today. One particular area of benefit, maybe to briefly mention, because it has an interesting connection to what we have discussed, is benefits of AI in using AI for regulatory purposes. So there are many ways in which the use of machine learning and AI tools can make the work of regulators more effective in terms of monitoring markets, ensuring compliance. Anti-money laundering monitoring in financial services is just one example among many. So regulation, AI for regulation, especially in the context of regulating AI, is a very promising area among many others.
Yeah, thank you. And Greg?
Just quickly, I really like this idea of having like a meta AI, so AI checking other AI to see if it is misbehaving. I think the challenge there is to get a data set that you can train the AI system on to recognize when other AI systems have misbehaved. But as those data sets or as there's more practice that comes into place and those data sets become available, this becomes a viable option.
Perfect. Thank you very much, everyone. And I'll hand over to Fernando for the final words.
Thank you. It looks like Dominic is working for us, because exactly it left the door open for what we were going to say. In spring 2022, we are going to have our third event of this series. And as we are going to deal mainly with the use of AI in the public sector and the judicial system, part of the focus will be in how can it be used to improve the situations that we have, and not only the negatives. So thank you everyone for being with us for an hour and a half, and immense thank you to all the panelists. A real privilege to be here online with you, and hope to see you very soon. And keep your eyes and ears open, because in addition to next event, we might be soon start talking and publishing about a publication. So thank you again.